primarily the closest to our heart. So there are messages popping up. So let me know what I need to do. It's gone now. So at the outset, I must thank immensely, profusely the IPGA, and I'm really humbled in the presence of Dr. Jayabalan, Dr. Manju, and I know Dr. Jayabalan as a person who is one of the most dynamic professional I have met. It was when I went to his college, but I have heard a lot of things which he has been doing, and the dynamism and the special respect which he has for women. I really, really am a big fan of him personally speaking. I must thank Dr. Manju to set the ball rolling, and it would be absolutely required to put on record the appreciation for the president of the central body, that is Dr. Nasa, and Dr. Manju, who is like the power behind this show, I'm very sure. And definitely Madhulika, who has been able to bring us all together on this very, very auspicious day. Dr. Jayabalan told us that it is a lot of milestones for which we have collected here. And I'm very happy to be a part of this journey, which is definitely going to be a roller coaster journey, professionally speaking, in the coming years and times. Thank you all. I take permission from the chair here so that I can initiate my presentation. We have selected a topic, and Dr. Jayabalan has already sort of ignited the mind. And I really liked the igniting the young mind and then making to learn the whole concept of IIYML. It is highly appreciative. And I really congratulate each one of you to be really bringing this to this generation, which is absolutely ready to take that.
Ma'am, you have been muted. Your voice is not out.
Okay, fair enough. Thank you so much for telling me. So Madhulika, I would request you, because there are certain pop-ups which are coming up. Let me know if at all there are certain issues of the mic or nothing, so that I can be absolutely in sync with the presentation.
Ma'am, actually we are joining. That is why we are getting those
Achha,
messages.
okay. Fair enough. So is it visible? Is it visible?
Yes, ma'am. It's clearly
Okay.
visible.
So the topic, very brilliantly, I think Dr. Jayabalan, in a very short span of 30 seconds, had used this word, intangible. So I'll start with defining what intangible matters. So there are things which I can touch with hand, there are things which I can see and visualize, but there are also things which are there in my gray matter, which are not to be touched, but they do matter. So when we talk of something intangible, it is something which we cannot touch physically, but we are primarily the owners of that energetic intellectual property. And henceforth, the title says intellectual property rights, intangible matters. We cannot ignore the intangible. As we proceed in the presentation, hopefully we'll try to understand the title and how actually it is relevant to us as Indians. And flying up with the energy of Chandrayaan-3, I think we are all ready to make in India and the world to see. Absolutely. I think the energy is good enough and the Josh is good enough. So we start with the simple, what we call as understanding what intellectual property is. Intellectual property, as the word property suggests, is nothing different from any other property. You must be having a property which can be sold, rented, gifted, leased for a limited period of time. On the same lines, this intellectual property is also, which is nothing different from the normal property, but it is much more than that. So it is created by the exercise of intellectual faculty. It is the result of person's intellectual activities, which are ultimately used in commerce. But these rights are statutory rights, which are governed in accordance with the provisions of corresponding legislations. And yes, we have to remember one important thing, that intellectual property rights reward creativity and human endeavor which fuel the progress of humankind. We are all teachers here, we are all researchers here, and fueling the creativity of the human mind is something which is very close to our heart. Let us start talking about the different types of intellectual property. There will be a lot of variations to understand while we take this topic of the types of intellectual property. Intellectual property can be of types like number one, we have patent, we have industrial design, we have trademark, trade secrets, copyright, geographical indications, and layout designs of integrated circuit. So we'll be talking and spending time on each one of them and trying to understand. And I'm sure that we have a lot of students who have joined in. I'm really extremely happy to have them. And we'll try to make the things easier for them, that how all these types of intellectual property are something we should look into and maybe try to create as well. So let us talk about one of the most oldest of the intellectual property, and that is primarily referred to as your industrial design. When we talk of industrial design, they usually refer to the creative activity which result in the ornamental or formal appearance of a product. And normally, whenever we have a design in mind, we have a clear objective that these designs will protect the, number one, will register it. And normally, the person who will create it, he can be an artisan, he can be an originator of a design. We can call him a person who is creative, and he is the bona fide sort of owner of that particular design. So we need to protect it. So whenever we talk of intellectual property, like we will protect our car, our house, or our money by putting it in the bank, we would also like to protect our intellectual property. And when we talk of the design, whenever we create something, we put a lot of effort on it. Designing is not that easy, and that design has to be protected, and that design has to be absolutely, the person who has created it should be given enough value or enough credit for that particular design. So this type of property or this type of intellectual property, which we are calling as industrial design, has to be protected so that the other people do not use it without the permission of that creator. The next one is something which is closer home. We will understand it. You can see a lot of figures here where you are seeing the names like Coca-Cola, Levi's, Nivea, IBM, Barbie, and many more other things like HP and OX and Ford and all. All these things are nothing new. You can recognize maybe this figure, and you know that it is for Android. You can recognize this particular type of sort of cartoon, and you understand that this is associated with nothing but the WhatsApp. The moment you see this M, you know you are talking about McDonald's. So these are some of the very popular brand names which has got typical identification. The identification could be by virtue of the word or device or label. It can be a number, it can be something which is putting an sort of impact on your memory, and you keep on registering it and you keep on remembering it even subconsciously. The moment you say, for example, this figurine, you understand that this is something to do with the smartphone, something to do with the Android. So these trademarks can either be a word or a letter or a device. It is usually simple to design. And when I create a trademark, I should keep in mind that it should be easy to speak and maybe spell and remember. It should not be a very difficult entity, because if it is difficult, then I will not be in a position to remember it. And normally when I create a trademark, my intention is that my customer should remember them without any efforts on their any tangible efforts. So they have to just remember it. The moment they will see it, they will remember, okay, this is talking about this particular product. So when I design a trademark, so one has to remember that it should be easy. And normally this word is usually invented or a coined word. The words which directly describe the character or quality of the good should not be adopted. So what I am wanting to say through this statement is that the individual, when he is looking for a trademark, there has to be some uniqueness. They should be easy on your tongue, they should be easy to remember, and they should not be big lines, or they should not be very difficult and complex things which a person will feel difficult to remember. So these are some of the basics things which you would remember while you are talking about and thinking about the trademarks. Here comes another figure where you can see that the trademarks are not only limited to the speaking part. So when I use the word brand name, I am talking about the utterable or vocalized part of the brand, which I speak by the name. A brand mark can be something which is distinctive design. Similarly, a device can be something, a brand or the trade device can be something which is talking about a figure like a bird or a landscape or a building. And we can also use letters. You must be seeing these letter forms like IBM, GM, LB, 3M, and you remember all these companies. The moment I say IBM, it must be hitting you hard that, okay, we are talking of that software company or we're talking about the IT company. You can just simply see this figure here. So you can have a shape, you can have a name, you can have a color, which can be your trademark. You can have a logo, like in case of Volkswagen. As I just told you, that simple symbol of M and this line slogan, I'm loving it, is telling me that we are talking about nothing but the McDonald's. So these are some of the basic things which are to be borne in mind while you are thinking and talking about something which we refer to as the trademark, which is your one type of intellectual property rights. The next thing which normally is sometimes confused, let us try to understand what this trade secret is. Again, trade secret is an intellectual work or product which is used for business purpose. And this trade secret can either be a formula, it can be a device, it can be an idea, process, pattern. It can be something which give you a competitive advantage in the marketplace, a novel idea that is not common knowledge and is kept in a confidential state. It may include recipes, ingredients, codes, manufacturing costs, etc. हम अक्सर बोलते हैं कि दादी माँ ने ये जो दाल बनी है, अब दाल माखनी बनी है. North side people are very much into eating dal makhni, and they always say that this has got a typical taste which my grandmother has. That is her trade secret. Or the thing which is being this type of biryani can only be produced in Hyderabad, so we call it as Hyderabadi biryani. It has got a typical spices which are present there, but nobody knows how much is to be added. Nobody is even understanding that how it can be prepared. You can read the recipe, but the taste is different from what we get in Hyderabad, for example. So this is a trade secret. And we don't know what is the type of the addition of the spices, although we might know what type of spices are to be added, and that becomes a secret, and hence the word trade secret. Normally you will see, can you tell me that how do you made this presentation? Oh, I cannot tell you, that is my trade secret. So we use this in a very common language as well. But when we talk of the IPR part of trade secret, we have to be ensuring, and we have to remember that trade secret cannot be one. This is how it is different from trademark. Trademark can be registered, it is protected by the federal government, but trade secret cannot be protected by federal government. It has to be protected by virtue of the employment contracts. What do I mean by this? That the employees, for example, the Coca-Cola recipe is not known to anybody. And the Ruah Afza recipe, the drink which is produced by Hamdard Waqf Laboratories, the actual taste, how it is developed, is not known to anybody. So the employers who are actually manufacturing these two things, for example, they will sign a contract that they would not reveal any ingredients and the process of adding one after the other to anybody, and that is, they are bound with that. So what do I mean by this statement? That when we talk of trade secret, it is the sort of responsibility of the company, responsibility of the employer, that recipe or that sort of secret is not given out to the world. And that is the way they will keep on having their product year after year, year after year, without losing their taste and without losing their business on that particular thing. So that is what we know when we talk about the trade secret. As we move to the next category of the IPR, we talk about something which is very, very relevant to us as sort of researchers, as authors of the book, as maybe producers of articles, and anything which is literary in context. So we produce thesis. If at all we have teachers in the audience, I would request them that normally we are very, very sort of ignorant of the fact that the thesis which we are producing should also be having the copyright. So when I produce a PhD thesis, it should be my first responsibility that I should attain a copyright and I should make a claim that this copyright work is for the supervisor and for the student and for any other co-supervisor. So if I start doing this, that will actually ensure that my research is not copied and I can sue if I want to. I can bring to the bring the person or the person who has copied my work to the law and to the court if I wish to. But if I don't actually put the copyright thing in my thesis, then I am leaving it open for anybody to copy, for anybody to take it up and so on and so forth. So copyright is one thing which a government is giving me and I should be using it as a researcher and as an author and a creator of the intellectual property. And what actually when I talk of copyright, it is usually the right to copy and make use of literary, dramatic, musical, artistic work. Everything is covered in this. And normally, even the computer programs and the softwares are nowadays covered under the copyright. So you will see that there's a lot of battles going on somewhere in the West or somewhere in the East as well, or in China and all, on the copyright of the programs sometimes which they use and they don't take permission or they don't pay the money to them. So the computer programs are the latest additions to the list of the copyright because they will need a lot of creativity. They are not done so easily. So your computer programs and softwares are also under the copyright. It is basically a proprietary right or the ownership right, which is there and it gives the creator or the author or the person who has created that software the authority to use that program or that book or that research as per his or her requirement. So we need to really think about that, what copyright and how copyright should be protected. The next thing which we are talking about is there's a different periods of the copyright for which primarily one should always remember when we talk of the copyright of a drama or a musical or an artistic work. It can be a copyright ownership. You can imagine it is up to the lifetime of the author plus 60 years. So the generations which are coming down will be the owner of that property, which could be literary or dramatic. Similarly, if a photograph is clicked or a cine film or the sound is being recorded, or you have a protection of around 60 years in case of the broadcast performers and the other things which are there in the literary domain or the creative domain. This is protected for a period of 25 years. So you can see that the copyright has got such longevity that it can extend from the age of the author to 60 years, and sometimes when it is for cine film recording. So that is one reason. I must give you an example here that most of the film producers or the film directors, they will coin the name of their movies, which they might not make this year or the next year, and they might be making it maybe let us say 15 years down the line. So they keep on coining these words, coining these names of the movies and putting them under the copyright. Nobody else will use it. If at all they intend to use it, they will pay that person just for simply putting those names of the movies in the Copyright Act. So this is the way we can primarily use this copyright, which is under the intellectual property right. The next important thing, I would really want you to pay attention on something which is a very important IPR, but not so much of like understood and is usually not taken very seriously. You must be amazed to know that India, being a multi-diversity country, a country which has got so many cultures together, is definitely leaving out or missing out on so many registrations of the geographical indications. So before we get into the detail, I would really love to explain that what these geographical indications are. This is another variety of intellectual property. And these geographical indications are usually originating in a certain geographical area. So they are associated with a particular part of the country, particular I would say geography of that country or a region of that country. So we have very typical examples that you must have heard it, that we use the word China silk, then we use the word Dhaka muslin, we call Venetian glass. So all these three are from three different countries, and these three products are being associated by the virtue of the association of the name of the country or the place, we immediately know that the origin is in this country, or the originally muslin, which we are talking about, Dhaka muslin, is a special variety of muslin which is originated in our neighboring country, Bangladesh, and the place from which it has originated is Dhaka. So what exactly this geographical indication means, that there has been a very beautiful combination of the nature and the men, and traditionally using a particular technique to produce a product over generations and generations, centuries and centuries. There has been a link of that product with that particular place, and which results and evolves into something which is acceptable as intellectual property and called as a geographical indication. Let us take it further. In case of our own country, we are a part of the World Trade Organization, and this World Trade Organization, it primarily made us into one of the major stakeholders and of the intellectual property domain, and one of that was primarily the geographical indications, and we protected this in the year 1999. And this law of geographical indication of goods Registration Protection Act of 1999 was initiated, and it came into action on 15th September 2003. Under this, the group of people who are indulged in a particular tradition or particular production of a product can, as an organization or a group of a people, can register that product and get the protection under the head of your GI. So the beautiful Indian country, we have got lot many of these. Around 5,000 of the GIs are still waiting to be claimed. Just imagine that if we are able to claim those 5,000 and more than 5,000 of GIs, how much of value we will add to our commercial or our commerce and trade. There are some of the examples here. For example, when we talk of Bikaneri Bhujia, we know that it belongs to Rajasthan, and there's a place by the name of Bikaner. It is a typically like a savouring snack which we use in North India very, very prevalently, but it comes from the place which we know as Bikaner. Similarly, a typical of the design, we can have something of a chappal, which is your footwear, and which it comes from Kolhapur, so we call it as a Kolhapuri chappal. Similarly, we get Nagpur orange, and Alfonso mango. All of them are coming from Central India and Maharashtra. We have your Kanchipuram saris, Darjeeling tea. We have Assamese sort of cloth and textile, and we have basmati rice. So there are many, many things. These are some of the examples, and these examples are primarily telling us and helping us out to understand that our country is producing so many very typical. Then your Rasgulla, which was primarily also in a battlefield because there were many claimants of that Bengali Rasgulla. But finally, the West Bengal is taking that as it's here. It's what we call as your geographical indication. We move to the next. Some of the other examples, these are some of the things which I was talking of: the Assamese tea, the Nagpur oranges, the Alfonso mangoes, the basmati rice, the Bikaneri bhujia, the petha from the Agra, and the silk with down south from Kanchipuram and the other areas. So you can just simply see that we are having a lot of things which are specific to that particular area, and when they get registered under the law, they are referred to as your geographical indications. And I want to just clarify one small thing here, that when we talk of the application for the registration of the geographical indication, it is usually not done by an individual. It is done by the association of persons, organization, and the producers. The reason why it is so, because when it comes to the geographical indication, it is not limited to a particular individual. It is limited to that particular area. So when we talk of Agra Petha, it is not only one individual from Agra who is preparing this Petha, but it is all strewn around the area of the Agra. Similarly, Nagpur orange are not the sort of ownership of only one individual. All over the Nagpur, you will have a lot of people who will be indulged in producing oranges. So this application will not be an individual application, rather it has to be registered and can be gotten from the association of persons, organizations, or by a group of the producers. That is something which is very different when we talk about the GI indications. My next type of, the next section of my presentation primarily would be dealing with the most important part of the intellectual property, and that is your patent. When I talk of patent, it is something which has to be, I would say, a part of every researcher's life. And when he thinks about an idea of creating a formulation or creating a drug delivery system or creating a new molecule, the first thing which should cross his mind or her mind or the group's mind is that how can I patent it? What should be the means and ways by which this particular drug or formulation will reach many, many people and will actually make a person heal from a particular disease. So if I start thinking like this, I would primarily be contributing hugely to the concept of Make in India, to the concept of making affordable medicine. And henceforth, it becomes very important for all the researchers, not limited to pharmacy, but all researchers, that they should know what are patents and how they can be helpful to us. So in the next section of the presentation, I'll be dealing more about the patents. As I have been telling in the beginning itself, that like any other property, it is another property and it is called as a patent, which can be bought, sold, assigned, licensed, gifted, or inherited. It is an exclusive right. It is an there has to be an owner of this particular invention. The person or the group of persons can be the owners. You will have to be ensuring that who is the primary investigator, who is actually the secondary investigator. It usually is an exclusive right. It is a way of excluding others. I'll talk about this exclusion thing in detail in a bit. And it is usually for a period of 20 years. So these are some of the highlights which should be borne in mind as we proceed in the presentation. When we talk of the patents, as I just told you, is one of the most important intellectual property. And it was for the first time ever that in the Indian Patents Act of 1970, it was first figuring in. And they gave us a period of 20 years, which is still relevant to us, wherein any invention will be the owner's property till 20 years. And how it proceeds, we'll be definitely talking in a bit as we proceed. The inventor has to file for the patent first and then make his or invention to public. It is not possible that you are using it for 2-3 years and suddenly you feel like patenting it. So it is always important to remember that the patenting is the first step and then bringing your invention to the public domain and not the vice versa. A patent has to be applied in each country by the inventor in order to claim his right. So what do I mean by this statement? That the patent is a regional property. For example, if I'm finding and getting an Indian patent, the execution, the registration, the use of that patent will be limited to the country India. But if I get a patent in Australia, then the domain and the region of its execution will be in Australia or Austria, whichever country I'm talking about. So we have an example, and there has to be a lot of things which are to be borne in mind so that we know that who can patent, why he should be patenting it, and why this person or the group of scientists can do it or cannot do it. I give an example here that there is a company by the name of Himalayan Drugs, and there's a group of scientists who are working there. The patent of the drug is actually getting developed and granted in the name of the company and not the scientist. The drug can have the final product can have patent which can be related to the composition, related to the process, related to the product, and so on and so forth. So what is the take home message from this particular small discussion? That if it is a company and a scientist is an employee there, then the company is the owner of the patent and not the individual or the employee. And the drug formulation or anything which is patented, you can have a numerous patents. For example, if I'm talking of this smartphone, it is not a single patent. It can be more than hundreds and thousands of patents when I am holding this one phone. The patent of the screen, the patent maybe of the software, the patent of the chip which is present there, the chip software which is being used there, or anything for that matter. Similarly, in the formulation, we can have a patent which is only limited to the composition, patent related to the process, and patent related to the product itself. Let us now talk about something and find out that what is actually patentable and what is not patentable. Or we'll talk about 3 important criteria which makes a invention or which makes a product patentable. So when we talk of the patentable inventions, there are certain criteria which are to be fulfilled. The first criteria is that of your novelty, the second is your non-obviousness, and the third one is your utility or commercial application. When we talk of the novelty, what do I mean by the word novelty? It is on this basis that the invention is judged, taking into consideration the knowledge available in the particular domain. Let me just maybe talk about it in a little detail. That if the person is creating something new, and the people of the same acumen and same intelligence here are not able to think about it, public domain it is not available, so that particular thing will be novel. So when we talk about the second aspect is that there has to be certain tests which are to be borne in mind about this. So that tests primarily are that the claimed matter should be different from the state of the art in respect of at least one physical feature. So if I'm having the novelty, so at least there should be one particular difference in the physical aspects of that particular thing which I want to claim as a patentable thing. In case of a medicine, it is not always necessary that it has to be a novel agent. It can be a substance which is new. It can be a combination of two products which is new. It can be something, let us say, the combination of a polymer and a drug, an old polymer and a new drug and a new polymer, and a new drug, new polymer, and a new indication. So there can be a lot of combinations and permutations which can be undertaken. And so in order to get the test of the novelty done, a product cannot be rendered novel by mere fact that it is produced by a new process. So for example, if you are producing a pen, and this is a pen which is already existing in the market for the last 15-20 years, but you have made it by using another process. This person maybe have used one method of plastic molding, you have used another method of plastic molding, but the end result is a plastic pen with these two different parts which are separated. So you cannot claim this to be a novel, so therefore this thing will not be patentable. One has to be very cautious about the fact that how the novelty testing is done, because if anything which is patentable has to have this concept of novelty. There are three criteria, as I just mentioned. The first one is the novelty, the second one is the unobviousness, and the third one is the utility or the commercial viability. The second part is your non-obviousness. An invention is considered to be non-obvious when compared to what is already known. So what do I mean? For example, if we are pharmaceutical scientists and we are working in different labs in an organization, and I always tell my students that the best way of finding out the novelty and the non-obvious is when you are discussing in a scientific deliberation. If you talk about a product, oh my God, you know what we did? We had this polymer, chitosan, and then we loaded this drug, and that drug was loaded to a capacity of 100%, 100%, and the encapsulation size was like primarily this. And the response of the person who is listening is, oh my God, wow. If you're getting this response of wow, if you're getting that response that, okay, my God, how did I not think about it? Oh my God, it was so unobvious. So the moment these types of expressions are there in your peer group, you should be very highly appreciating your efforts that, okay, I am on the path of getting something new. So this unobviousness is something which is everybody is knowledgeable, but this knowledge which primarily I am talking about was not obvious to other things. They were not able to think the way I was able to think, and hence I am a step up, and I know that I am having something in my hand which is going to be patentable. The third thing which is very, very relevant and more relevant in country like ours is that every device or apparatus or anything which I'm producing after such a lot of hard work has to have a commercial viability, has to have a utility. It cannot be prepared with so much of hard work and it goes to the drain and not benefiting the people of my country or the people of my society. So the product has to have It can be again an apparatus, it can be a product, a material, compound, substance. But finally, it should be made in a manner that it can result in commercial viability or it has some industrial application. So if anything is able to pass these three filters of novelty, non-obvious, and commercial viability, then we are on the path of getting a patent for sure. These are some of the steps which are there. So we just quickly summarize what we had been talking about. There is something, there is a problem solution approach has to be there if I am talking about a inventive step or a non-obviousness. So there are multiple types of products which are already available in the market, but those products are having some problems, or there is a requirement, or there is an unmet need. When there is an unmet need, that is going to make me think, and I will have a problem solution approach. When I will have a problem solution approach, I will do something XYZ, whatever my plan is. I will get something which I call as your unexpected surprising results. I will make use of certain, it will make use of certain technical advancement. It should not be a mere alternative solution to the existing problem. It is not simply 1 plus 1 is equal to 2. It can be 1 plus 1 is equal to 3.5 or 4 or whatever. And it has to definitely be an enlightening thing, and it has to improve upon the prior existing art in that area. For example, of a formulation, it might be able to increase the efficacy. It is giving me synergistic action. It is replacing a drug which was having a lot of side effects, and I have a new drug now which is having much lesser side effects, and it is going to be mind boggling, and it is going to change the society, and it is going to really impact the society well. So if I'm able to get everything in my work, in my research, in my product which I'm thinking about, so I'm definitely on the path to get a patent, and this qualifies to become a patent. The third one, again, the part was that of your industrial applicability. That means the claimed invention, anything which it could be an aeroplane, it could be a medicine, it could be a device, whatever it is, it could be either in a pharmaceutical field or an agriculture field. The claimed invention shall be industrially applicable according to its nature and can be made in the technological sense in any kind of industry. What do I mean by this statement? Anything which I'm producing or anything which I'm thinking of producing should be acceptable to our industry setup. It should not be like that, okay, there should be a format that, okay, I have created this particular formula and I will need these types of machines, maybe a tableting machines, maybe a injection filling machine or whatever it is. It is, what I mean is that it is adaptable to a particular industrial setup. You cannot say that I have invented it. How, where will I make it? I don't know. No, it is not patentable. So it has to be supplied in a manner or made in a manner that it is industrially acceptable, and it is primarily going to be helping me and helping whenever I talk of industry, I actually talk about making huge numbers or making on a larger scale. So anything which is made on a larger scale, I'm sure will be benefiting larger society and the larger amount of people or the larger number of people. And hence this third test of industrial applicability is very, very important. There has always been a lot of debates in our heads as researchers that why should we be patenting? Is it so important? It is so sort of I would say out of the world thing. Yes, it is. So when I talk about the patenting, there are so many things which are happening in and around. When I talk about the patent, I usually am doing something which is I am motivating and encouraging more inventions. Our Honorable Prime Minister, in the last few years of his prime ministership, has been really working too hard, and most of the Indian organizations and even the world organization is actually trying to align with that thought process of Make in India. The encouragement, the starting up of a businesses will only happen if we are able to innovate. So anusandhan, innovation is the key for everything. So when we talk about the patents, it has to encourage the inventions. We are also providing, by disclosure, we are making the knowledge, we are telling that, okay, this is a patent, and then we open up a lot of things. There will be many people who will be coming and rushing to you that, okay, if you have a patent on the anti-cancer drug, can we buy it from you? Can we use it for the patients in the other countries, and so on and so forth? And the patent, by virtue of its right which is being given to you or the recognition which it brings, it is usually making, and I'll put it this way, that it will result in one thing which is called as your monopolies. It will give you exclusivity, but then it will also help to generate public interest, and it will give a lot of impetus and push to the new researchers and push to the new type of discoveries which will benefit the society. So there is a huge number of benefits of the patents to the patentees. How does a patentee will benefit? This right is an exclusive right. This is something some people call it as a negative right also. Let us try to understand that why it is a negative right. For example, if I patent a particular thing, for example, let us say that this smartphone was made by me. I know that it will work and it will do wonders, but I choose that no, I will not allow anybody to manufacture it. So if I do not allow, nobody will get benefited from this discovery. And it becomes my exclusive right. The reason why this is called as a negative right is that there is a product which is there in the market, there is a control which is happening, but what exactly is required is that this should be brought to the public domain, and I am stopping that person to not use it. So hence it is called as a negative right. I'll take a small break because of the azan which is happening, because that voice is not allowing me. It's okay, I'll just cut
Yeah,
off
ma'am.
for a couple of minutes and let
Yeah,
me
yeah.
know how many minutes are left, because I think I can go on
No,
and
no,
on.
no. No, nothing.
Okay. I'll just take a break of 1.5 minutes or so.
Yeah, please.
And meanwhile, you can type your questions also. If at all, I'll be very happy to respond to the students' question and others as well. Am I audible?
Yeah, ma'am. You're audible.
Okay. So I was just talking about this important aspect, that how these patents benefit the patentees. As I told you that it's an exclusive right, it could be a negative right, but why it is called negative, I just explained. But nonetheless, it is usually giving a lot of power to the person who has created that. He can make, use, exercise, sell, or distribute an invented article or process in India. The right can be shared. He has all the right that how we can share it, license, or sell it. It can give me the right or the owner's right to initiate legal proceeding against any infringement. The invention can be commercially exploited without fear of copying, imitation, or unauthorized use during the term of patent. So these are some of the things which are the benefiting things to the patentee, and the type of leverage or the type of exclusivity he will enjoy or she will enjoy is something worth mentioning. As we move further, Continuing with the benefits of the patentee, the published patent specification is an ocean of scientific knowledge and technological information. So that will be a big contribution. The patented inventions are open to public for free use after the term expires or ceases to be in process. It is very simple to understand that if the patent was not for 20 years, or if it was unlimited, then there would be a lot of monopolies which would occur, and the beneficiaries of these products will be very less in number, because they might result in huge amount of costs. So once the patent gets expired, it is open, and India as a pharmaceutical hub thrives heavily on the off-patent drugs. If it was not a concept of getting off-patent, we would primarily be not doing what we are doing today. We would not have become the pharmacy of the world. So that is something which helps us. The rules and regulations are in our favor. It also avoids duplication of research and acts as a stepping stone for further research. This is something which is worth mentioning. Normally, when I start my research work, I also go in for something which is called as your prior art search. When I say prior art search, what do I mean? That when I want to start my PhD work or my any research work, I would want that it should be a new work and nobody should have done it earlier. So I go to the various patents, I find out that what is being done, what is not being done. So if whatever I was thinking was already being done by somebody, then I would stop myself and I will rethink, and I will maybe that becomes a stepping stone for my further research. So I will not reinvent the wheel. I would rather think what I say nicely and maybe more energetically, and maybe try to do something better which was already done. Then, of course, when we talk about the patents, it has to be patents, but I think the parents would also fit in very well. So they give us the valuable guidance for the planning, the research and development, planning strategic protection for the IP assets, forging strategic alliance, identifying possible collaborators and competitors. So these are some of the greatest of the benefits which a patent will give me if I look into it that way. But then there will be a very logical question that is everything patentable, or do we have certain limitations on that? So let us try to understand what are not patentable inventions, or what are not subjects of patency or being patented. The first thing is that there is a lot of living things and non-living substances which are occurring in nature. There could be a situation that you go somewhere and you are the first one to maybe enter into that region, and you find out and you discover that these types of ants, we have seen ants which are black and red, but these ones are something which are orange in color, and then primarily they are making some new products which is present on the surface of the soil. You will say, Eureka, I have got this new thing which is there in my mind, or which I have seen for the first time. Mind you, you have not created that. You have just discovered that. A mere discovery of anything which is already present in the nature is not the subject of patent. So we cannot patent anything which is present in the form of nature, which must have been already there and was waiting to be discovered. We cannot patent the topography of integrated circuit. Similarly, a mathematical or a business method or computer program is not patentable. We cannot patent a method of playing the game. So when we play cricket in a particular manner, we cannot say it is patented by Britain or it is patented by India. We cannot maybe patent the plants and animals in whole or any part, because there again, there can be different varieties of things which are present in the nature. We cannot patent them. We cannot. In India, it is patentable. The next thing which I'm talking about is patentable in USA, but not in India. I cannot patent a process for medical, surgical, diagnostic, therapeutic, or other treatment of human beings in India. Imagine if the COVID kit was patented by the owner or the researcher. If the Covishield was made and it would have had been patented. If, for example, any medicine which was used at that point of time would have been patented, then we would have never survived the pandemic. That is the primary reason that why India has not been allowing the patentability of all the things which are resulting in the treatment of human beings. India being an agriculture-based country, we cannot patent the method of agriculture and horticulture. We cannot patent the method of terrace farming. So the point which is to be understood here, my dear students, is that we know what is to be patented, that it has to have 3 basic criteria. Similarly, we should also be aware that what should not be and what is not allowed to be patented. So as we move further, let us talk about the legislative framework. It is a law-based thing. It is the protection is given by the government of India, so it has to be undertaken a particular legislative framework. So we have the Patents Act, which was launched in the year 1970, and it was eventually amended in 2005. Then we had the Patents Rule amended in 2006. We had the Designs Act 2000. Then we had the Copyrights Act, which was originally in the 1957, but later on amended in 1999. Then we have primarily the Protection of Plant Varieties and Farmers Act in 2001 and 2003, Geographical Indication Act, as I told you, 1999, and Trademarks in the Air 2002. So as we are knowing the different varieties of the patentable things, we should also know that what are the types of the rules which are governing each one of them. So the Indian Patent Act primarily, it was first enacted in the year 1970. And India, we know after in the year 1947, we had a lot of issues of restrictions which were there. If you go into the history of this whole thing, because of the colonial regime, we primarily were not self-sufficient, and it was the hard work of our then Prime Minister and the government of India that we could do something which is now called as a green revolution or a white revolution. A lot of industrial changes happened, and today, by God's grace, we have come to that level that India has become the first country to be launching its own satellites in all over the world, all over the globe. And very recently, Chandrayaan-3 has really put everybody in awe. And it has been done indigenously by the Indian scientists. And that is what the whole concept of this intellectual property rights are. So when we talk about the patents, it was the sad story in the 1947 when we had to depend for so many things onto the world outside. But as we progressed, and in the year 1970, we had the first ever Patent Act. This became very, very important for us to undergo into the concept of patenting. Otherwise, we would still be highly dependent for our normal medicine on the world. Imagine a country like India not being able to produce its own medicine. We would have been in the worst of the scenarios. So this was usually the first thing, and the major highlight of this time, historically speaking, in the 1960s, the medicine prices was very, very high. India was giving medicine at the highest prices as compared to the world. And as we talked about it, as we started thinking about the various innovations, the other things which we did in this area, and today we stand as the pharmacy of the world. So that journey from not having anything to start with to a time when we are in a position to supply medicine to the majority of the global countries says a lot about our sort of dedication towards innovation and patenting. Although we are not innovating the drug molecules a lot, but there's a lot of work which is being going on in the industry as of now. And there's a lot of things. We are basically a generic oriented sort of country, generic medicine oriented country, but the continuous efforts of getting newer and newer patents in the areas of formulations are something which we are working very, very hard towards. So when we talk of the patent administration in India, this is again very important thing for all of us to understand that how this whole concept of the patent works. We have hierarchy of officers in patent office. So the patent office or the IP or the Indian Patent Office is the body which deals with the patent and granting of the patent. The first highest person is called as your Controller General of Patents. Then we have the Joint Controller of Patents, we have Deputy Controller of Patents, and we have Assistant Controller of Patents and the Examiner of Patents. Each one of us who have done pharmacy and who have done post-graduation, we have got a lot of means and ways by which we can primarily enter into the office of the Indian patent and then maybe find space for ourselves. A lot of people, a lot of courses are being run wherein we are trained for being examiners of the patents. Government of India runs a lot of courses, they hold a lot of examinations, and this is one area which needs to be explored by all pharmacists. So when we talk of the organization structure, it is usually coming under the Ministry of Commerce, Industry and Industrial Policy and Promotion. We have the Controller General of the patent. The patent offices are primarily located in metros like Kolkata, Delhi, Mumbai, and Chennai. Then there are divisions of the various places where the patent offices are. For example, in these 4 cities, similarly, the trademark registries happen in these 5 cities. Similarly, some of the other areas like patent information system is being taken care of the institute, which is there in Nagpur. The geographical indication registry is happening in Chennai. So all these, all over the India, we will have certain offices of the IPR, wherein depending on what type of the IPR you are dealing with, you will have to go in for the sort of the process of registries and all. So we basically have an intellectual property appellate board. And this, as the word appellate suggests, it is dealing with the appealing against a particular sort of patent. The headquarter of this IPAB is in Chennai, and it also conducts the hearings on rotation in Chennai, Delhi, Mumbai, Kolkata. So usually whenever we are talking about the word, if I use the word appellate, it is very understandable that there will be certain things which needs to be appealed, wherein you are not accepting a decision of a particular organization or a court. Therefore, you can challenge that. And the challenging of all the IPRs will happen in front of a special board, which is called as your Intellectual Property Appellate Board. So this was this again comes under the Ministry of Commerce and Industry, and normally it is effective from April 2007. Again, an important thing is that let us now talk very quickly. I think the next few minutes of my presentation, I'll try to cover as much as possible about the invention of a patent and how it starts. So this will need attention of most of the researchers here, that how do we start the concept of getting a patent? The first thing is that we go in for the step of conceptualization of invention. My dear students and researchers, I will urge you again and again that whenever you think of a research, do not limit your thought process to only creating a thesis or a research paper. Think of your project in a manner that how I can visualize it is something in the form of an IPR. If you start your research with this visualization, I'm sure that the conceptualization of your project will be very different from the ones which we do today. We have to first conceive a project, and then we will have to submit a disclosure. So when we talk of the submission of the disclosure, it simply tells me that how I will actually do my research and what are the various parameters which I will engage in. Then it will be submitted for patentability assessment. All the 3 filters, as I have just explained to you, whether it is novel, whether it is unobvious, whether it is having the industrial commercial viability. Then there will be a concept of drafting of a patent. Then we'll go in for filing of a patent, publication of a patent application. Then we will submit it for examination. After the examination, once it is published, it will come in a public domain. People can maybe object to it, that maybe they can have some contradictions, maybe they have certain cases against you, maybe certain thought process against you. So they give enough time, and after the publication of the patent, it is submitted for examination. After that, the response of the office, that the Indian Patent Office responses to it, and finally we undergo the process of getting a granted patent. So these are some of the steps which one has to bear through the journey of getting a patent. I will take one by one very quickly. When I talk of conceptualization of invention, I have to ensure that these 2 concepts of marketing as well as science has to get linked up. I will take 1 minute to explain this particular thing. Whenever we are talking about technology, whenever we are talking about a new product, we have to make sure that there is an unmet need or there is an unsatisfied need of the marketplace. You must be talking to your mentors or your guides and supervisors. Whenever you write a rationale for your thesis or your research paper, you simply have to give a reason why you are doing this particular project. Then you say that up till now, the conventional drug delivery system were giving us a lot of side effects. which were resulting in the cessation of the therapy for cancer. Therefore, there is an unmet need of making a formulation which is sustained release and which will reduce the side effects. So the anti-cancer therapy is much better. I have just given one sentence, but this one sentence will need a lot of understanding of the things, the market, that what is the unmet need, how I can actually create a commercial level for me, my product. And similarly, there has to be certain technological push. So these two pulls and pushes, that is your demand pull, which is from the market, and the technology push, which is giving me a commercial product, are the two important parameters when I should, as a scientist, think when I conceive or I start the conceptualization of my product. I have to link the marketers and scientists together, and then to develop a new technology which will give me good market possibilities. Submitting a disclosure means I will disclose different components of the invention, such as working of the invention, unique application, how will I execute, and so on and so forth. Patentability assessment, I just tell you that it will be the test of the invention. It will give me that whether it is the invention is under the government or the approved list. ऐसा तो नहीं है कि you have put something which is a non-patentable subject for the application, so that has to be rejected. Then it has to also have a background that before you, nobody else has done it. Therefore, my process or my product or my invention is having the three concepts of novelty, non-obviousness, and it should be based on the prior art search. The novelty of the invention will be established. After this patentability assessment, the novelty of the invention, and the next step is to then what we do, whatever. Now I know that my product has, or my project or my research, or whatever word I am using here, it has cleared the patentability assessment. Therefore, I will go in for the next basic step of drafting the patent application. The patent application is a legal document. It has to be drafted in a broadest of the terminologies. I would like to cover everything which can be covered in that. After that, I will go in for filing of a patent. Then there is a filing of the patent application. So that date becomes very, very important. And if for example, 2-3 people are filing the patent, and unfortunately or fortunately, there are similar things. The person who will file it the first will get the benefit of first to file. Therefore, filing the patent as soon as possible, as you are able to get the assessment report, you should not waste time and immediately go in for filing the patent. After some time, there will be a publication of this patent, and this will take around 18 months of time after filing. Sometimes we pay extra money or required fees, a little more money, a little more fees is paid to get a fast publication of the same patent. Then after this, if I'm paying extra money or I'm getting that paid, the fees amount is more, so I pay that. So my publication of my patent will happen within a month. Then after that, the patent application is sort of taken up for examination. It will scrutinized. It will be a very sort of microscopic scrutinization, and all the parameters of the non-obviousness, invention, novelty, everything will be taken care. And once it is established, what will happen is that I will get a response to the office. There will be certain questioning step. There can be certain clarity sought. And if everything is in place, then there will be a grant of patent after examination of all the objections which have been raised. There will be a patent number will be issued, and you will get a issue of the patent. And to keep this patent working for years together, there will be annual fees which one has to pay. So in a summary, but we can primarily say that there will be the step 1 of filing, then examination, publication will happen. After publication, examination will be happen. During the examination, there can be certain oppositions or clarity sought, and finally we will have the grant of the patent. I will just now, maybe towards the end of the presentation, that we have a lot of things which we can translate a molecule into a marketed drug. So we had this product, and this product is in collaboration with Jamia Hamdard and Arbor Pharmaceuticals, wherein we got a US patent granted for self-nanoemulsifying curcumin. So once we started this as a PhD research work, and then finally it passed through all the tests, not in India, but rather in US, which is the toughest market. And we were in a position to get this product which is in the market nowadays. One of our other colleagues was in a position to get this natural astaxanthin, and he had an exclusive technology which he has sold to a Chinese company, and that is again a big thing which has happened in Jamia Hamdard. Just coming to very quickly, what are the various types of patent application? We can have an ordinary application, which is a patent of addition, and which is the improvement of a already sort of a patented protocol. So we can have already a patent is there, we just add a bit of it, and that adding a bit of it is resulting in a better application of this. So such patents are called as your ordinary patents. Then we have a divisional application, wherein we primarily have a plurality of invention and it is closed in the main application. We have different parts of it and that becomes a bigger application. Then conventional application is something where I will get a patent in the countries which is the part of the convention. So by filing one patent, I might get a protection in maybe say 16 countries or 17 countries. So we have a European Union where we have 19 countries. So any patent which I get granted in the European Union, so if it is granted in one country, it will be applicable to all the other partner countries. There are different documents. I think this is something which we will learn as we will look into the process of patenting. We have got a lot of forms which are to be used for the submissions, like Form 1 is being given for the application of the grant of patent. Form 2 helps us for provisional or complete specification. Form 3 helps us to understand the statement and undertaking which is given by the applicant. Similarly, Form 5, Form 26, all of these are the, I would say, mandatory requirements or the rule or legal requirements which have to be taken care of. So these are the various forms which are available. A lot of things have to be filled in. There will be descriptions. This is a flow chart which is just helping us to understand that how a patent can be there. You can just see this algorithmic thing. We have an application. After 18 months, publication happens. There can be a representation by the other. There can be oppositions. Then you will have an examination. Then there will be a lot of questions which are being put up. So the patents can be either granted. Then the publication of the patent, this granted patent happens. There can be another opposition, and for each section of this steps, there will be a limited time. And finally, when all the opposition proceedings are there, you might contest in the front of an appellate board. And if at all, there can be a situation that a granted patent can even be revoked. So this process is continuously being taken care of while we are living our patent, while we are working on our patent. So this is just what we have just talked earlier. These are the steps. All these steps are, I would say, governed by the rules. So we have limited time periods for which all the things are being open, and then we have to respond. The final decision is that of the controller or the Indian Patent Office. There can be, and if at all, there is a lot of contention that the appellate board can decide, and the person can either get the amendment in the patent, or the patent can also be revoked. Some of the things which are there available on the website. This is just as a snapshot that how it looks when you enter into this website. Then there is a concept of an evergreening of the patents. This is a continuous. All the industries, they work so hard to get a patent. So what they usually do is that they keep on sort of adding certain new things. Little bit changes are there, but they are having all the three criteria fulfilled. So they keep on increasing the years of their patenting, and this primarily is referred to as your evergreening of the patent. You can have an example that a patent was granted in the 1995, and primarily it went on up to 2020 by simple changes which is happening over and over again. So there are certain ways and means by which a lot of industries, they keep on researching things. But mind you, always remember that even if the changes are smaller, they should be absolutely on the basis of the three criteria. If and only if these three criteria are fulfilled, then only there can be a grant of patent, and then only this evergreening can happen. Then there are certain patenting activities in India which are under the myth. So let us try to break this myth. The first myth is the knowledge is not a tradable commodity. So one has to remember that like all other properties, even knowledge is a property, and we can simply use that property to earn money, to earn name, and to contribute to the societal benefit. We unfortunately have insufficient institutional infrastructure, but I again will say that however infrastructure you are having insufficient, but if the intellectual property is there, we can definitely overcome the shortcoming of the infrastructure. Nobody can stop us from thinking. Nobody can stop us from designing or creating a new product. So even if I'm not able to execute at my own institute, I should not be bothered down. Then we have inadequate focus during the project planning and execution. That is what I meant when I said that when I design my project today, I should be very sure about that my project is not limited to a publication or a thesis. It should go in for some commercial viability. Then we usually have a pro reverse engineering mindset. So normally we believe in reverse pharmacology, reverse calculation, reverse everything. However, we deny the fact, but we are very good at it. So we have to change our mindset, and we might have to think on for the newer and newer things. There is always a general complaint attitude, ye nahi hai, wo nahi hai, we are short of this, we are very short of this. So we have to overcome that complaining attitude. The temptation to acquire short-term gains has to be limited. We cannot let ourselves to just simply go in for a publication with a high impact, although easier said than done. It is a very tough choice for all the teachers and the researchers, because the requirement for submission of thesis is a paper and so forth. Nonetheless, if we are able to design and execute our project in a proper manner, then maybe we can get the patent also filed and we can get a publication also. We usually always suffer from professional and financial insecurity. So a lot of universities are pumping in a lot of money in order to help the teachers. I'm sure that many institutes in Chhattisgarh might also be getting benefit from their schools and their universities. Major part of R&D being in government sector, we usually blame that the research is not our domain. We are not expected to do research, but mind you, most of the molecules, even the vaccine which saved a lot of people in the world, was a product in a university in USA. So we have MIT University, we have Harvard School. So all these universities are playing a very major role in R&D, and that has to be also replicated in our country. We have very less emphasis on the IPR oriented research, and there's a lack of public awareness. So these can be the things which can be busted, and we should incorporate all these thought processes while we are talking of research, at least at our own school levels. We simply can, we are agriculture based country, and there's a lot of herbal things which can be sort of taken care of, and we can be really on top of the world if we think about the IPRs in the traditional medicines. So we have got a huge number of products, the curcumin snack, which I just explained to you and showed an example, that it is also a traditional medicine. So we should think about how we can keep on patenting the newer things. There's a lot of policies which are there and supporting us. We have got a lot of resources which can be sort of accessed by all of our students and researchers. And we should, one thing is very important for all of us as researchers, is that we should start looking into as a prospect of commercial viability, and think about that how these policies which the government is helping us out can be utilized for our research. We have a lot of conventions. Then this is something I was talking about, this convention on biological diversity. As I just told you, that there's a lot of benefits which can be given to the local community. There's a lot of information and knowledge which comes from our folklore medicines. We can scientifically take this up and create certain new formulations, new compositions, and that can help us naturally using and those resources, and that in a sustainable manner. And we can actually have a lot of benefit to the people who are engaged at the local level. Then there is a rules and regulations. Everybody is aware that it was because of the TRIPS, that is trade related aspects of intellectual property, that we became a partner of it, although we tried to sort of push it for a very long duration. But finally, when we were one of the major contributors, and we were benefiting not only personally as well as a country, but also for the world. And these are the rules, and they have to be like, as what I always feel is that we normally as teachers do not emphasize much on all these things. So it is high time that we should have special courses and special discourses on this IPR thing, so that the students are highly motivated and they are triggered to think better. We have, as I just told you, that the government of India has done a lot of work, and one of the work which needs mention is creation of a traditional knowledge digital library, that is TKDL, wherein most of the scriptures, most of the Ayurvedic things which are being used in our country are in Sanskrit. Similarly, in the Unani, they are in Urdu and Persian. So the government of India took a lot of efforts, and they took up the sort of hardcore published books, and they made it into a digital format, and the database which they have created under the name of TKDL. I would request some of you, if you find some time sometime, please kindly look into what this TKDL is all about. So there are a lot of 230,000 formulations have been obtained from the ancient texts. We can think about patenting them, we can think about using them, and then maybe making it much more commercially viable. Very quickly, I'll just give you a few of the examples that the patents are not limited to only pharmacy. Pharmacy is one area where we can work, but you can see that there's a lot of patent. Simple creation of a sleeved blanket for swaddling and bedding infants is granted a patent. A nursing cover, which can be used for covering the body from the top to the end in a multiple fashion, is a patentable thing. A physiotherapeutic designing chair which can help out patients who are with stroke can be patentable. We have a lot of supportive protection systems which can be patentable. A simple fashion scarf which is useful for general fashion, but it is also having some lightweight semi-sheer thing. So the idea is that even small things, big things which you think are not even worthy of attention are as good as to be being granted a patent. You can just see in this example, you have this very scarf or a shawl, which is used for a baby privacy during nursing. And this has a flat piece of semi-transparent, semi-sheer, lightweight thing. It is a simple cover, and this has been granted as a patent. Then there's a lot of patents in nursing. You can see that design specific beds for people who are having issues in mobility. Then certain things which can support the back and the foot. These are many things which are primarily granted as patents. Just a few more things, that how small discoveries can actually get translated into patents and make people's life easy. You have a lot of things, simple magnetic devices which can be used, simple intelligentsia, taking suggestions from the doctors and the patient and create a thing which is helping them to bear the weight. In pharmaceutical sciences, as I told you in the beginning, I'll very quickly summarize that there are many ways and means by which patentable things can be there. We can patent the drug substance itself, which can be a chemical composition. We can patent the method of use, where a drug is used to treat a particular condition. We can definitely patent a formulation, which is a physical form of a drug and a method of administration. And we can patent a manufacturing process for that particular formulation. And there are a lot of combination and permutations which can be used for granting of patents. There are certain case studies I might have to skip because of the paucity of the time, but just to keep you intrigued is that as per the rules and regulations, there will be situations where there will be different patents which can be challenged, and these challenges are put up under the patent appellate boards, where the government the authorities will have an argument, maybe with an MNC. This is a typical example where this blood cancer drug of Gleevec was getting off patented. The IPO rejected the novelty of the drug as it was not substantially different from previously patented ones. There was a lot of debates on it. And finally, there was a bad news for the multiple drug companies that the IPO's decision was not in their favor, but it was in much favor for us because the anti-cancer drug by the name Gleevec then became much affordable for the patients in India. Then there was this typical case of the microorganisms where it was for the first time in the Act of 2002. There was this case in a very famous case by Diminaco AG and Control of Patents Design. And it was for the first time that somebody has asked for the patent for the microorganism. So, and it was debated a lot. And finally, the IPO's decision was challenged legally. IPO was saying that it cannot be granted. And the Dominaco et al. Had put the case that it can be granted a patent because this is not the natural form of microorganisms. Rather, they are being mutated or they are being changed in order to get something out of it. So that was something which was a very watershed time for the Indian patent authorities and the Indian folk as well, and scientists as well. These are some of the top 10 patentees in India. These are the companies from USA. Of course, India In India, we have this CSIR as one of the major bodies and organizations. Samsung India Software Operation is again having a lot of patents, but I'm afraid to say that based on the size of our country, we are primarily not doing up to mark when it comes to patenting, because we shy away from these processes and we are not in sync with the requirement of the patency. Luckily, at Jamia Hamdard, we have a very good research ecology, and I'm very happy to dedicate this one of my patents, which was granted in a record time of less than 1 year. And it was on something which was very commonly used. We had tried to create a nanofiber which would destroy the biofilm. The biofilm is a covering which is being presented by the microorganisms, bacteria, which does not allow the drug to get penetrated, and hence there is a bacterial resistance. So we tried to formulate a nanofiber which was having a biofilm disruptor inside it. So the biofilm disruptor would release, and after releasing the biofilm disruptor, the biofilm will be shed out, and the bacteria will be then exposed to the activity of the antibiotic. And the same bacteria which was earlier resistant will be easily killed by the this particular formulation. Luckily, while the mission Chandrayaan was on, in the same week, we got another patent of our, that is on 24th of, it was the second day, 24th of August, that we got another patent granted. And this was again for a hand-free spray bandage of povidone iodine for the treatment of any wounds. So these are some of the motivations which keep us motivated to do research which is new, and we try to we are also, but traditionally speaking, all researchers and particularly academician researchers, we do not think much about the patenting. We usually think up to the level of publication and submission of a thesis. Again, as a peer, as a contemporary researcher, I would request that although it might be very challenging, but we should not shy away from thinking of our projects, conceptualizing our projects with an intention to primarily break the tradition and get a patent as well. And of course, I think this is going to be motivating for most of us, the mission Chandrayaan 3, and that is something I dedicate this patent to this mission of Chandrayaan 3. And being a woman, I'm really proud to be associated with these types of developments. And I acknowledge the great motivation which that women team has actually provided to all of us by doing this greatest of the feat, which was recently seen by the whole world. That is, this patent I dedicate to the team of the mission Chandrayaan 3. I always believe that there is always a lot of challenges, and we have to continuously keep on overcoming these. And this poem of Robert Frost is usually what keeps us motivating. I always say that woods are lovely, dark and deep, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Thank you so much for your attention. I must put on record my appreciation and the support which Jamia Hamdard gives us. And we are an NRF rank 2. We had been at one position consecutively 3 years. And we have got a very dedicated IPR cell, which helps us to gain insights into what intellectual property is. We run a Pharmacon lecture series where we keep on inviting a lot of alumni and a lot of researchers who keep on sharing it. Of late, we had this PGDPI course also, which is run by our School of Open Distance and Learning. Thank you so much for being such passionate and very dedicated listeners. I really thank all the organizers to give me this opportunity, which is one of the most cherished opportunity, because I love to share whatever little I know, and that too with the young minds, which needs to be ignited. Thank you so much, each one of you. With your permission, I will stop sharing.
Sure, ma'am. Thank you, ma'am.
Thank you so much. I know I actually took a lot of time, but I trust this would not go vain, and primarily I was able to do some justice to the topic which was given.
Definitely, ma'am. Definitely. Thank you so much for such a wonderful deliberation. And I'm sure that all the participants must have benefited and thinking of patenting their intellect in future. Thank you so much, ma'am.
Thank you so much.
And now, hello. Now I would request Dr. Nagendra Singh Chauhan, sir, Treasurer, IPGA Chhattisgarh branch, to present a certificate of appreciation virtually to our keynote speaker, Dr. Zeenat Iqbal ma'am,
Thank you so
as a
much. Thank
token
you so
of
much.
our gratitude. Just a moment, sir. I'm sharing, sir.
And I must say that if at all, I know that there were so many things which could have been better explained. And unfortunately, I'm a bit down with viral fever, so there was a little bit of extension on my end. And I would really appreciate that if there are any things which are needs clarification, and if at all I can be of some help to any one of you, my email is there with Madhulika and also with Jayabalan sir. So you are most welcome to seek any type of help. And if there are any pointed question, I'll be very happy to take some of the questions if the time permits. Otherwise, you can write to me and you can take any help which you would wish to.
Definitely, ma'am. Definitely. We can take up a few questions. Definitely. I'm facing some issue. Just a moment.
No problems at all.
Just a minute.
And Jayabalan sir, I must really congratulate and appreciate your efforts.
Thank
That
you. Thank you very much. ma'am.
these types of deliberations, although they are virtual, but they are of high help, a lot of help for the students to connect with from the
Thank you.
comfort of their homes and their colleges.
Thank you,
Because
ma'am.
it is not,
Today I'm supported by my friend Dr. Yogendra Singh. Since I am in another duty out of station, so Dr. Yogendra Singh was running behind the show.
Okay. Thank you. I appreciate
Thank
his
you.
efforts
Thank
as
you,
well.
Dr. Yogendra.
Thank you, each one of
for
you,
your
because
efforts.
it cannot do without a teamwork. And I'm sure that you have a great team who assists you.
Yeah.
Thank you so much, ma'am. It was really wonderful listening you and how wonderfully you explained each and every aspect relating to patenting. So it
Thanks,
was
Dr.
really, it
Manji.
was a wonderful session. Thank you so much, ma'am.
Thanks, Dr.
If
Manji.
somebody wants to ask any questions, you can unmute yourself and ask questions. You are
If at all there is, because I've taken a lot of time,
you
so
are
there
given
might
the
be few.
opportunity to unmute yourself. Chauhan sir, you want to say something on this?
No, sir. Thank you, sir. You both have given a good presentation. Actually, I just joined very late
No problems.
when Madam Jeenat Madam explaining, and it is very good. Madam is explaining in the very short form, as well in the for the student that are working M.Pharm as well as PhD student. They give the detail of the what are the patentable and what are the steps they have to follow during filing the patent, and what the point on which point they get patent. They describe very shortly and briefly the person that are working in the area of pharmaceutical as well as in the natural product area. I'm highly thankful to both speaker. They give us guide to our IPGA fellow of Chhattisgarh. Thank you, madam.
Thank you so much. If you allow me, I'll take your leave now.
Madam, we have to share your certificate, madam.
Okay.
One second,
Ma'am,
Please.
we have some participants who have some questions.
Please. No worries at all. Madhulika, kindly carry on, please.
Sure, ma'am. I got personal messages from them. Okay. We got question from Geeta Sahu, ma'am.
Please. Okay,
Please,
please.
ma'am, please unmute yourself and go ahead with your question.
Kindly, I'll be very happy.
Good afternoon, ma'am.
Good afternoon, Dr. Geeta. How are you?
Fine, ma'am. Ma'am,
Please.
one question from my side.
Please.
What does it mean to license a patent and why it is done?
Okay, so in the beginning, when I said about intellectual property right, I said that it can be sold, it can be licensed, it can be leased out for a particular period of time. So licensing of a patent is a way by which the benefit can be extended to the society. For example, if I am not in a position to use that patent because of any limitations of finances or industrial collaboration or viability, I can primarily give it to another industry. And sometimes there is a concept of compulsory licensing. I'll give you this very critical example. There was this anti-cancer drug which was sold in our country for pediatric patient at a very, very high price. The government requested the MNC that kindly reduce the price for the Indian patients. They said no. There were a lot of deliberations, a lot of debates, but unfortunately they did not allow, or they did not align with the government's requirement. So the government sent out a notice to all the pharmaceutical company that if some company can take that patent and do a formulation or make a formulation and primarily sell it in India for the benefit of the Indian patients. And this thing is called as your compulsory licensing, that the government gave a license to the new player, and the company which got this license was Natco, and they could prepare that formulation at a much cheaper price with a benefit for the Indian patients. So licensing is a simple tool by which the knowledge which has been generated through a patent and grant of a patent can be given out to another company which can manufacture it and maybe use that commercially for the benefit of the society. I trust, Dr. Geeta, I was able to satisfy
Yes,
your
ma'am.
query.
Yes. Thank you so much.
You're welcome. You're welcome. So I would request, I think there could be many people who are here who are into teaching and researches. I was like, it would be great if we can create some groups, and I'll be very happy to keep joining on smaller levels as well, where we can primarily have deliberations and awareness workshops on patenting. That would be much help.
Good afternoon, ma'am.
Madhulika,
Good afternoon, Prachi.
I'm facing issue while solving that problem. Actually, I'm unable to unshare this my screen. Actually, ma'am.
It's
No, it
okay,
is there.
ma'am.
It is visible. It is visible, Madhulika. That was visible. Prachi, you have a question. You can carry on, please.
Yes, ma'am. Do I need a patent attorney agent to prepare and file a patent application?
Mostly because we are not very well versed about the rules and regulations. So it is always good to have a support of a patent attorney. But I would say, personally speaking, for the 2 patents which we recently got granted, we actually prepared our own claims, because a researcher will be the best person to know what he or she is creating. So it is always good, I'm sorry, it is always good to have your own claims written, but for a better language and a better way of presenting it, hiring of a patent attorney is always advisable. We should always take help from a professional attorney who knows what to skip and what not to skip. But if, the primary patent can be written by our own selves also, by the researchers. It is more or less like a thesis only. We have to just take out the salient features of our research and put it in a particular format. Hope, Prachi, I've been able to answer your question.
Yeah. Ma'am, Princely Jnana Honey raised the hand. You can unmute and ask the question.
You're most welcome. Any one of you could unmute yourself. If whatever little I can explain, I'll try my best.
Princely?
Princely, if you have a question, you are most welcome to unmute yourself. It could be maybe by mistake also, sir. It's okay. Indrajit ji, if there is any question you may ask. Madhulika, don't worry about that certificate presentation. I acknowledge graciously the efforts which you have taken and your team, and it is I accept it without it being displayed in that manner. I could see my name, and I really appreciate the efforts. It's absolutely fine. We may consider it done. No worries on that.
Thank you, ma'am. Thank you very much. I think some technical problem is there, so we are not able to see.
No issues at all, sir. No worries at all, sir. It's absolutely understandable. Madhulika will be generous enough to send it to my mail, and that I will cherish for my life. Don't worry at all. So I understand that we always have limitations, but together we will overcome it, and we'll keep inventing. We'll keep doing good work. No worries on that. Thank you so much. If you allow, I'll take your leave.
Thank you so much, ma'am. And I would also like to extend to Jayala sir, who had been such a support in organizing, in actually for the smooth running of this program. Thank you, sir. Thank you so much. Jayabalan sir is there?
Yes, sir.
Yeah, ma'am, I am here. I'm here.
So, sir, when do we have the next conference?
Okay,
you were talking
thank you,
about
sir.
of
Thank you
IPGA?
so much.
Pardon, ma'am.
Thank you, sir. Thank you very much, sir.
I'm not
I think
hearing you clearly.
we'll meet in Delhi soon when you are here for
Sure.
the conference,
On,
inshallah.
on October 1st, ma'am.
Hopefully, I'll try
Yeah.
to be there. Thank
Yeah,
you
yeah,
so
please.
much, each one of you. I think we
Thank
can
you, ma'am.
disperse
Thank you.
now. God bless
Yeah,
each
ma'am.
one of us.
Thank you, ma'am. Thank you so much.
Fine.
Yeah.
Thank you. Thank you. Thank you.
Thank you, ma'am.
Thank
Manju,
you.
ma'am.
Thank you, sir.
Thank you,
Thank you,
sir.
Thanks a
Monica,
lot.
ma'am. Thank you.
Thank
Nagendra, sir. Thank you.